Be ready. Start. What is taking cognizance has not been defined in the Criminal Procedure Code, and I have no desire to attempt to define it. It seems to me clear, however, that before it can be said that any magistrate has taken cognizance of any offence under section 191A Criminal Procedure Code, he must not only have applied his mind to the contents of the petition, but he must have done so for the purpose of proceeding in a particular way as indicated in the subsequent provisions of this chapter, proceeding under section 200 and thereafter sending it for inquiry and report under section 202. When the magistrate applies his mind not for the purpose of proceeding under the subsequent sections of this chapter, but for taking action of some other kind, example, ordering investigation under section 156(3) or issuing a search warrant for the purpose of the investigation, he cannot be said to have taken cognizance of the offence. In its broad and literal sense, it means taking notice of an offence. This would include the intention of initiating judicial proceedings against the offender in respect of that offence or taking steps to see whether there is any basis for initiating judicial proceedings or for other purposes. The word cognizance indicates the point when a magistrate or a judge first takes judicial notice of an offence. It is entirely a different thing from initiation of proceedings. Rather, it is the condition precedent to the initiation of proceedings by the magistrate or the judge. Cognizance is taken of cases and not of persons. There is no bar against registration of a criminal case or investigation by the police agency or submission of a report by the police on completion of investigation as contemplated by section 173 CRPC. If a criminal case is registered, investigation of the offence is done, and the police submits a report as a result of such investigation before a magistrate without the previous sanction of the central government or of the state government or of the district magistrate, there will be no violation of section 196 1A CRPC and no illegality of any kind would be committed. It is necessary to mention here that taking cognizance of an offence is not the same thing as issuance of process. Cognizance is taken at the initial stage when the magistrate applies his judicial mind to the facts mentioned in a complaint or to a police report or upon information received from any other person that an offence has been committed. The issuance of process is at a subsequent stage when, after considering the material placed before it, the court decides to proceed against the offenders against whom a prima facie case is made out. The question relating to the need of sanction under section 197 of the code is not necessarily to be considered as soon as the complaint is lodged and on the allegations contained therein. This question may arise at any stage of the proceeding. The question whether sanction is necessary or not may have to be determined from stage to stage. Further, in cases where offences under the Act are concerned, the effect of Section 197 dealing with the question of prejudice has also to be noted. Before proceeding further, we would like to add that at the time of taking cognizance of the offence, the court is required to consider the averments made in the complaint or the charge sheet filed under section 173. It is not open for the court to analyze the evidence produced at that stage and come to the conclusion that no prima facie case is made out for proceeding further in the matter. However, before issuing the process, it that is open to the court to record the evidence and on consideration of the averments made in the complaint and the evidence thus adduced, find out whether an offense has been made out. On finding that such an offense has been made out, the court may direct the issue of process to the respondent and take further steps in the matter. If it is a charge sheet filed under section 173 CRPC, the facts stated by the prosecution in the charge sheet on the basis of the evidence collected during investigation would disclose the offense for which cognizance would be taken by the court. Thus, it is not the province of the court at that stage to embark upon and sift the evidence to come to the conclusion whether or not an offense has been made out. We may also observe that grant or refusal of sanction is not a quasi judicial function. Thank you.